Hello friends, in the series on income tax cases, today we will discuss a very important case in which a very pertinent issue was before the Honorable Delhi ITAT bench, and the issue was that whether the assessing officer has the power to reject the books of accounts of the assessee only on the basis of some audit qualifications by the auditor of the assessee. This issue has been decided by the bench in the case of Assistant Commissioner of Income Tax versus South Asian Hospitality Services Private Limited, and the matter is reported in 138 ITR Tribunal at page 117, and the date of the judgment is 7th May 2025. The present case relates to the assessment year 17-18. There was survey on the assessee, and in that survey the department made a view that the assessee has shown less disallowances under section 40A clause IA on the basis of form 3CD of the assessee, which is the audit report, which is the tax audit report, and on the basis of cash deposit made by the assessee, and on the basis of higher turnover shown by the assessee in service tax returns. The case of the assessee was chosen for scrutiny under section 143 subsection 3. During the assessment proceedings, the assessing officer, based on the qualifications of the auditor of the assessee, rejected the books of accounts. The assessee made addition for cash deposit under section 68 and also applied a rate of 8%, which is there in section 44 AD, which is for the presumptive taxation, on the turnover of the assessee of rupees 6 crore. Although the assessee was not falling in the presumptive taxation under section 44 AD. The assessee objected to it. The assessee said that in the case of the assessee, the rejection of the books of accounts is not justified because there is no mention or there is no reasoning given by the assessing officer for rejecting the books of accounts other than some qualifications made by the auditor of the assessee. When the matter was before the CIT appeal deleted the addition made by the assessing officer under section 68, but at the same time upheld the addition on the basis of rate of 8% which was being taken by the assessing officer. The revenue and the assessee both filed the appeals, and when these cross appeals were heard by the tribunal was of the very prima facie opinion that the assessing officer in the present case rejected the books of accounts without indicating how books were complicated. The view was that in the present case, the regular losses incurred by the assessee cannot be the basis for rejecting the books of accounts, and the tribunal said that in the present case the assessing officer has accepted the sale turnover of the assessee but at the same time rejected the expenses of the assessee. The tribunal was of the view that in the present case the assessing officer did not show how he was not satisfied with the correctness of the books of accounts, and the AO was also failing to demonstrate how the method adopted by the assessee was against section 145 subsection 1 and how the results declared by the assessee were not as per section 145 subsection 2. The tribunal said that in the present case, making the addition under section 68 and adopting the rate of 8% was without any rationale. The assessee was following the same system of accounting over a year, so on the basis of the consistency also the additions are not justified. The tribunal made a remark that the businessman knows how to control his business, and if the assessing officer was having any apprehension about the complexity of the nature of the operations of the assessee, then it was the duty of the assessing officer to refer the matter to the special auditor and then should have followed the due procedure of law before making the addition. The tribunal said that in the present case, the CIT appeal before deleting the addition under section 68 has given the detailed findings on the cash deposit. So the deletion of addition by the CIT appeal under section 68 is also justified. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus South Asian Hospitality Services Private Limited and vice versa. And this matter is reported in 138 ITR Tribunal at page 117, and the date of the judgment is 7th May 2025. Thank you, friends.